and then we'll get started. Okay, so we're going to introduce the panel now. So this panel is on youth climate courts, hosting your own human rights trial for people and planet. So it is about a youth climate court is a public trial that calls the local government to account on explicitly human rights grounds. This panel will describe the purpose and manner of the youth climate court trial, how it can be organized, and what the key roles are: the judge, the prosecutor, the jury, etc., and what they entail. Youth climate courts are a transformative new tool that can give young people a powerful public voice and genuine agency in affecting real change in real government, partly through inspiration and partly through direct public pressure to their local communities. Just a quick tech update. If you cannot see yourself or cannot hear yourself, that is normal. In the webinar function, you will not be able to see or hear yourself. However, if you have questions, there's a Q&A box at the bottom right-hand corner, and you can type in your questions and we'll answer them at the end. So our first panelist is going to be Dr. Tom Kearns. Dr. Kearns is from Seattle College in Emeritus Professor of Philosophy and the founder and director of the Environment and Human Rights Advisory Board. Dr. Kearns will provide an overview of what climate courts are, how they work, their human rights grounding, their structure, genesis, and goals, their benefits to youth organizers, and their benefits to the local governments to which they issue summons. Next, we will have Maya Stout. Maya Stout is a 16-year-old high school student and the director and prosecutor of Youth Climate Courts Newport, a leader of Oregon Youth for Climate, and Ms. Stout will describe the Youth Climate Court, and she and 8 fellow high school students are organizing to put their city government on trial for not protecting the community's human rights. She will describe participants' roles, the rights at issue, prosecutors' arguments, witnesses they intend to call, and mandates they will issue if the government is found guilty of not meeting its human rights obligation vis-a-vis the climate crisis. Next, we will have Judith Preston. Dr. Preston is a solicitor admitted to practice in New South Wales and the Northern Territory of Australia since 1982. She holds a BA LLB from Macquarie University and a master's in environmental law from the University of Sydney. She commenced work in 1982 with the Northern Land Council, NLC, primarily representing Aboriginal traditional owners in land claims in the Northern Territory and related to other legal needs in the Aboriginal communities. Dr. Preston will describe how the Youth Climate Courts model in being used informs and empowers law and non-law students to hold government and statutory bodies accountable for their climate impacts and assets. Next, we will have Professor Donna Craig. Professor Craig is a specialist in international, comparative, and national environmental law and a policy at Western Sydney University in Australia. She has over 40 years experience in environmental law research, legal practice, teaching, and working with communities, NGOs, environmental organizations, governments, and corporations. Professor Donna will address the pedagogical applications of youth climate courts tools and how it can be embedded in clinical legal education. And last but certainly not least, we will have Robin Goldberg. Ms. Goldberg is a Juris Doctorate candidate expected in 2022 at University of Windsor Faculty of Law in Windsor, Ontario, Canada. Ms. Goldberg will describe the Youth Climate Court project she has undertaken locally in Southern Ontario as a clinical training component in her education as a second-year juris Juris Doctorate candidate at Windsor University Faculty of Law. The project introduces young people to climate change, its impacts, and political solutions, with hope that they will feel ready to begin a journey towards true justice for the environment and its inhabitants. So we will start with Dr. Tom Kearns.
Thank you, Lisa. I'm glad you described all of our who we are, because that's going to save some time here. So today we're looking at youth climate courts as a brand new, unique form of human rights advocacy that young people can use to address the climate crisis. As a general rule, there are three possibilities available in human rights-based climate advocacy. One class of things is telling the story. That's personal narratives and first-person accounts by witnesses. A second kind of thing that can be done in human rights advocacy for the climate is claiming moral authority by reference to human rights impact assessments, UN reports that demonstrate the connections between climate change and the risk to human rights, rulings of the Permanent People's Tribunal session on human rights, fracking, and climate change, and the Declaration on Human Rights and Climate Change. And the third class of activities that can be used in human rights advocacy is exercising moral power by means of things like people's inquiries, people's tribunals, youth climate courts, truth and reconciliation commissions, restorative justice circles, and so on. So today we're looking at the youth climate courts model. So the youth climate courts model, whoops, I need to share this screen. There we go. Is that all viewable? Okay. So there's these three, oops, why is this not working here? There's those three things again. If anybody wants this PowerPoint later, just let me know. All these links are live. So youth-initiated courts are youth-initiated, youth-organized, youth-led, youth-conducted. Young people are in charge of the whole thing. They might ask to have an adult mentor involved that they would consult now and then, but not necessarily. And so a youth climate court has a youth judge, this is the model, by the way. And then, there'll be variations from this model, but this is the model. So each court will have a youth judge, youth prosecutors, youth jury members, and they will put their local government, their local city or county government on trial for not meeting its human rights obligations vis-a-vis the climate crisis. And if that government is found guilty, then the court issues a mandate, or maybe a few mandates, to that city to be completed by a certain date and brought back to the youth court for approval. If the youth court approves, that's fine. If the youth court doesn't approve, they might send what's required back to the city to make it better. So roles include a youth judge, a youth prosecuting team, jury members, youth witnesses who could speak for themselves, for others who couldn't attend, for future generations possibly, for the earth, for the oceans, for river systems. And witnesses, of course, expert witnesses could also be called. And one of the advantages of holding these things, these courts online like this, is that expert witnesses could be called from anywhere in the world. And then there should also be a liaison person between the youth court and whoever the government representative will be, so that the poor representative doesn't feel blindsided by things, that they can, someone is helping that representative understand what's going on, what the next step in the organizing process will be, what will be expected of them, and so on. And there needs to be, of course, a media organizer, because so much of the power of things like this, civil society, things like this, depends on media coverage. And then there needs to be a technical support organizer, especially if if it's going to be done completely online, just because there's always glitches. So the trial process goes like this. It's pretty straightforward. A group of young activists get together and just declare themselves to be a youth climate court. Then they decide which government they want to put on trial. And then after they get themselves organized a bit and figure out how things are going to proceed, who's got which roles, they issue a formal summons to that government, and written and in person, maybe at a city council or county commissioner meeting, to send a representative to the youth court. And then on the appointed day, the youth judge gavels the court into session. The prosecuting team makes its argument, calls witnesses. The defendant government does the same if it wants to. And then there's closing arguments. The prosecution makes a short closing argument, and the defense, of course, gets the last word. And then the judge passes the question to the jury for deliberation. And I'm imagining that there would be a break here, then maybe a lunch break for an hour or so, when people could eat, but the poor youth jury doesn't get to eat. They go off to their room to deliberate and come back with a verdict. And the question that is to be decided by them is, given what is required to address the climate crisis, has this government done an adequate job of doing its share to secure its citizens' rights with respect to the climate crisis? And the verdict can be yes, they've done their share, or no, they haven't. And then the prosecution's argument is a fairly straightforward one. It's got these four main elements to it. The first is that respecting human rights is essential for people to enjoy a minimally decent life. That's what human rights standards aim for, is their moral minimums, moral floors. And the second point is that governments, you defendant governments, central purpose is to ensure that rights are respected and secured. That's what governments are for. And yet the climate crisis puts at risk most human rights, maybe all of them, like the rights to life, to security of person, to liberty, to water, right to education, right to an adequate standard of living, to special care and assistance for women and children, the right to a healthy and sustainable climate system, and lots of others. And the argument concludes, this local government is not meeting its fundamental moral obligation to protect these rights. And then, of course, each of these four elements is supported by evidence and witness testimony brought by the prosecution. So that all happens in the first part of the trial. Then there's this break, and then these are some of the specific rights. And then the court reconvenes. Judge asks the jury, have you come to a verdict? And if the verdict is guilty, then the court issues mandates. They've decided ahead of time which ones, to the government to be completed by a certain date and reported back to the youth climate court. One mandate might be to government, you have to declare a climate emergency formally. Another mandate might be, government, you have to develop a science-based, human rights respecting, comprehensive climate action plan, complete it by such and such a date, get it back to us. Another option might be, another mandate might be that you, city, have to enter into a formal restorative justice process with the youth court, with the restorative justice facilitator and so on. And then sets deadlines for those things. And then in the coming weeks and months, the youth court keeps pressure on until those mandates are completed and reported back to the court. And then the final step is for the youth court to gather up its documents it's developed and notes and so on, and put together a little report and send it off to the International Coalition of Youth Courts, where it will be archived as a resource for future organizers of climate courts. So here's a few other options. We talked the first three already. Another possibility is to enact a climate in all policies rule, requiring the city or county to consider climate issues in everything they do. Another might be to require that city or county to formally endorse and publicly display and actively promote the Declaration on Human Rights and Climate Change. Another mandate might be to amend the founding document of that government, its constitution or its city charter or county charter, to include climate language, to include, in fact, climate obligations. And that would put climate obligations at the very root of that government's policies. Another option would be to require that artistic installations be installed by the city in City Hall and in the county courthouse in around the city. Things like the climate clock and the climate ribbon, those are just two examples of really powerful artistic installations. So that's it. And I hope this has left you with more questions than answers. If you, there's more information available in two sources. One is this website, Youth Climate Courts, plural.org. And another is the little book on youth climate courts that's about 90 or 95% done and ready to send off to publishers. So that's the model of how youth climate courts work. Thank you. Lisa?
Yeah, Amaya, are you there?
Yes, I'm here. I just didn't know if you wanted to introduce her. I can start. So I put together a speech, and can you guys all hear me well?
Yes.
All right. So my name is Maya Stout, and I'm a 16-year-old high school student. I'm the leader and founder of Oregon Youth for Climate and the director and head prosecutor of Youth Climate Courts Newport. It terrifies me that scientists tell us what great disasters are coming, and then to see adults in leadership unable to do their job and rise to the challenge of stopping it. I advocate for climate because I understand that the mistakes we make don't fix themselves. I raise my voice because I can't vote for 2 more years and time is running out. Scientists gave us 9 years to take significant action to reduce climate pollution. An Oregon student in 1st grade today will just be graduating high school when their climate fate is sealed. Today, I'm here to represent my team of young climate leaders as we put together one of the first youth-led climate courts in history. We are putting our local government of Newport on trial for failing to protect our basic human rights against the climate crisis. Over the past years, we have acknowledged that we are in the midst of the greatest crisis known to human history, climate change. However, acknowledgement is not enough. The defendant, Newport City government, has failed to do their part in protecting our human rights against the climate crisis. Our rights to life, liberty, personal security, clean water, education, an adequate standard of living, care and assistance for women and children, and many other rights have been breached. This government has made a promise to protect the rights of the people. However, when our human rights are violated by the undeniable threat of climate change, that promise is no longer kept. It is their job to advocate and fight for their people, but when the people speak up, they do not listen. We are tired. We were on track to take direct action. Last March, our governor signed an executive order for Oregon to take action and go into a climate emergency. Yet nothing has changed. Families, children, workers in our area, communities have already begun to suffer from the initial effects of climate change. There is no getting better unless we act now. We hold the government accountable to enforce change. We're not targeting federal industries, governments, or rather local level governments. This way we can actually make changes specialized and unique to each community based on their individual needs. Our goal is to put Newport City government on trial to identify the consequences of their inaction so we can begin to create the changes needed for a safe and sustainable future. We need to understand that the effects of a proper governmental action are not made to benefit just one person, that every action we take from this day forward should be taken with an awareness of how it affects those among us. We are creating a climate court because it provides us with hope for the future, a future where we don't have restricted opportunities because of climate change. We stand for climate action because our generation needs a voice. We need a way to show our governments are guilty of inaction. They took an oath to protect our human rights, and all they need is someone to push them in the right direction. And what better people to do that than those who are going to be inheriting the world they created? What better people than the children who will suffer worse from climate inaction? We cannot wait any longer for the adults in power to sit back and ask for our generation to go back to school and to find a way to take carbon straight from the air. Our government currently has the solutions, but are refusing to use them. Our government is guilty of not doing their job to secure the rights of their own citizens. However, we are here to make that change. We are no longer satisfied with finger pointing. We know what needs to be done, who needs to do it, and how we need to move forward with renovation and change. My team and I are tired of excuses. It should not be our responsibility to spend most of our free time working towards climate action after 8 hours of school. It is not fun. I have not lived the teenage lifestyle that every movie romanticizes because reality has brought us to this fate, and we simply do not have the choice anymore. I do not have time to sugarcoat it and place blame on politicians or industries because I have faith in that our government can change. We have been asked, why local governments? Why not federal governments or industries? How are you actually going to make changes through a trial with no legal representation? At first, I didn't really know how to answer these questions because I honestly assumed that if kids came on their knees begging for a plan to secure their future, they would have an answer, right? But unfortunately, that was too optimistic. However, by targeting human rights and elected government officials, we can have a different hold on the crisis. Government officials have an obligation to protect our human rights, and we have proof that climate change is one of the biggest threats to human rights known to history. And if we prove that our local government is guilty for not securing our human rights, then they are morally obligated through the rules of democracy to form a solution. And we cannot fight the climate crisis until we have an effective system change. Tom Kearns, our climate court mentor, reached out to me with this idea. He proposed that I could put Newport on trial with any young people interested in climate change. Since around December, my group consisting of young high school women aging from 15 to 17 have been meeting every week and consistently working towards our trial date in May. Initially, we were all assigned jobs within the group. I'm the director, so I've been scheduling and leading the meetings, collaborating with our mentor, Tom, talking individually and assigning jobs to all of the group members, and helping anyone with their goals for the week. Our judge, Belia Grass, has been studying the process and intricacies of the courtroom. She will be responsible for overseeing the courtroom so it is both professional and effective. This includes researching protocols, vocabularies, dictionary, or duties of the judge, as well as studying both sides of the case to get a further understanding of what will be argued on our court day. Our prosecutor, Cadence Redwine, and I have been recording meeting notes as well as making documentaries, documenting any points our group discusses to use in our arguments. Cadence and I have been doing all we can to educate ourselves by researching online, looking up videos, watching documentaries, and trying to expand our knowledge on what, so we can create an inclusive, educated, and strong arguments. This is where our educational coordinator Lily Bell Bastingboy, plays a big role. She is responsible for the gathering of information and speaking to professionals so she can teach our group. We have a Google Doc and a group chat that she posts articles, stories, and any information we can utilize for our project. However, up until now, we have not told any other members of our community about this climate court. It is crucial we fully understand our arguments and become properly educated and prepared before telling Newport our plan. Our media coordinator, Lydia Miller, has collaborated with our school newspaper, learning to create press release and how to format an article so we can give it to local papers. So when we're ready, we can hit the ground running and utilize the pressure of press against our government to ensure our climate fate. The witnesses, Haley Fueling, Cascade Martin, Joelle Wynn, and Taylor Stevenson, all have specific rights and points they are addressing. This means that they have all been researching and writing their own witness statements, as well as collaborating with each other. We meet every week and communicate either through Zoom, phone calls, or texting workshops. During such meeting, we create a list of goals of the week, as well as further information to further expand our knowledge of either climate courts or either courts or climate. We're in the process of compiling the information, goals, experiences, and duties in order to create a template that other groups can use in the future. Based on our knowledge and experiences within the Youth Climate Court program, we can use all of our information to share it with other groups around the globe. I plan to become a mentor like Tom and help other young people interested in taking on this project. I want you to take a minute and think about your own government. Have they done enough to combat climate change? Do you live where the problem is rooted? Although we are equipped with the proper education and tools to move forward towards renewable energy, the United States alone makes up 50% of carbon emissions. Leaders of the G20 countries, which produce about 80% of greenhouse gas emissions, need to change more than anyone. We need not to leave other countries behind by being on the side of those facing the greatest threat of injustice. If we're going to make these changes, it has to be on a global scale. We are past the stage where one country can make an effective difference. I need you to empower the youth within your local communities. We have to get involvement from everyone for this to be effective. We need not to leave third world countries behind, assisting them and instead assist them in the process of converting directly to renewable energy. We need to force the G20 countries to move forward towards a renewable future. I need you to empower the youth in your community, whether or not you think it will make it a difference. I would like you to look back and be proud of the changes our government has made. My generation is predicted to face more devastation due to climate change than ever. The choices that your generation makes now may directly result in the suffering of your children or your grandchildren. The time is now to introduce the climate courts to the youth of your area. You can help us switch to a sustainable living. It's not just my future, it's all of ours. Let's take action right now. Thank you. And that's all.
All right, I think we're ready for Judith Preston.
Yes, okay. I'm going to try and share the screen right now. This one. Share. Right. Right, I'd just like to say to Tom and Maya, to start with, that was very powerful. And we are taking the messages. Our generation is sorry for what we haven't done, and not that it's going to solve the problems, but we are taking your position seriously, and Donna and I at least, I know we've tried to help change this, but a couple of people in Australia doesn't make for a solution. However, I am just going to give an example of what I have done. It isn't the true implication or the implementation of the model that Tom outlined, but what I did was I went to a freshwater conference in Moree, which is in the Murray-Darling Basin, and the Murray-Darling Basin is in crisis, and particularly because federal law and governance and state law and governance, and to an extent local law and governance, has been treating the water and the river systems like a resource that will never end. And the river systems and its communities are suffering from many things, including climate change. So I took the opportunity to try and encourage some science students, PhD students, to think about a youth climate model. Now I have to say that unfortunately the science students weren't really on board. They hadn't done the preparation, so we ended up having a forum of the federal and state governance representatives. So it was useful, but it wasn't exactly what I had in mind. So I'm just seeing what's happening here. Next slide. This is not really working here. So I'll just try and I'll have to just keep going down like this. Right, here we are. So yeah, this is the preparing for the Youth Climate Court. So I prepared what was called an easy class website. So I put all the information, documentation up there. Unfortunately, students didn't read it. So we basically explained it in the forum. We had the members of the conference coming out to outside, which I'll show you here. We were sitting outside in the heat. So climate change was very relevant at that point. And some of these people over here were the people that make decisions about water and the impacts of climate change. Unfortunately, despite my cross-examination, if you like, because the students couldn't participate because they hadn't prepared, basically the members of the government were quite defensive. So they were really not answering the question quite honestly, and we didn't get very far. So I thought, well, perhaps people with some motivation and some legal training would work better. So I introduced a team of people that I knew were very interested in the subject. They're all either law students or graduates. And you see a picture of them in the court where we held, was in the Land Environment Court, which is a specialist environment court, probably one of the more important ones in the world. This is the Chief Judge who presided over the proceedings. These are all the advocates who had a look at the materials and prepared a number of submissions on behalf of various stakeholders. So I put a real question. So the application was by the local community and the Guaidu wetlands, which is Ramsar listed. So it's an important wetland that is being severely impacted by a number of things, including water licenses, mismanagement, in my opinion, and climate change is compounding things. So we made an application under the Water Management Act, which is based on the argument that the state government departments, which was responsible for allocating water licenses, were really misunderstanding their duties, which was partly to protect the river and protect the use by communities. So that gave rise to an improper exercise of official powers and functions by state public officials. So it had the effect of operating to the advantage of the irrigation sector, because there are a number of industries that, in my opinion, namely cotton and citrus fruits and cattle raising, are in a very, they've been allowed to operate, and they've been allowed to take too much water, which has the effect of disadvantaging the environment and many communities. So the case study was that the youth advocates represented many of the stakeholders, so it was more like an inquiry. So they looked at how the Guardia wetlands are being protected and regulated from the adverse impacts of climate change. So we've got a list here of the number of stakeholders. So we've got all the government departments at the federal level, the state level and the local level, as well as the Land Council, Aboriginal Land Council, the Guardia wetlands themselves and the irrigators. One of these advocates, as a suggestion, said that future generations should have been included. So I take that point. So each of them prepared a 10-minute submission to the judge, suggesting an outcome for improved protection of the wetlands from adverse climate change impacts. So here are the questions: whether federal and state governments have adequately regulated and protected the wetlands as a Ramsar wetland of international significance with respect to climate change impacts. How are climate change impacts on the wetlands being assessed and how are they being mitigated? How are other interests of rural communities involved in activities such as farming, tourism, aquaculture considered in the management of the wetlands? Are Aboriginal cultural water values adequately considered and taken into account? Because Aboriginal communities in this area find it difficult to carry out their cultural heritage obligations, and recreationally, people are becoming sick because the water, because it's not running freely, is being polluted. And what role does water knowledge by Aboriginal people as custodians, as well as local knowledge holders, play in water decision making? And who speaks for the value, needs and interests for the wetlands? And how can the wetlands interests be better served by local reform policies and advocacy? So you can see here that I'm including not only human rights, but earth rights as well, or the rights of the riverlands and the wetlands. So as I said, it was held before the Chief Judge. He declined to make a decision because it was a case that might come before him. So he didn't want to have to be recused for bias. And the youth advocates were asked to provide feedback, and that feedback and information, a little bit of films and photographs of their participation is put on the archive section of the International Coalition of Youth Climate Courts. Tom mentioned that website, so it's in the archive section. So some of the feedback that we got from the youth advocates was that this youth climate court, even though it was a little limited, it helps solve a stigma that's prominent in younger generations that we don't have a voice when it comes to recommending changes. It prevents an opportunity to combat the issues with reference to hard and soft law. It also provides opportunities for non-science students, I suppose, or advocates to understand the science arguments. The youth climate courts were effective as a provider forum for young people to express and argue their views in a way that was taken seriously. And issues were addressed holistically because a variety of stakeholders were represented. So the forum and the format encouraged greater depth of research and preparation. So some of the improvements that the participants thought that it could be promoted through a variety of images and snippets from the moot, which is we've addressed. That's been put up on the International Youth Climate Courts Coalition. And as I said, to include a representative for future generations in the next iteration of the Youth Climate Court. So I think maybe I'll leave it there because the next part considers the academic and pedagogical implications for academics and in a number of areas. Thank you very much.
Thank you, Judith. Now we're ready for Professor Donna Craig. I'm sorry, you're still muted. look at the bottom left corner of your frame.
You can tell I'm an older generation. I plan to talk just very briefly about the potential role of youth climate courts as part of both formal and informal education, probably focusing predominantly on the informal. One of the frustrations of my long life as an academic and an activist is learning doesn't necessarily change behaviour, and it doesn't necessarily lead to empowerment of communities. And it's a particular issue now that we're faced with looking at screens as we are now. The most ineffective form of learning is a hierarchical form of learning. That is, the existing authority figure imparts it through a disembodied and a disempowering medium. So my generation in law rebelled against this kind of pedagogy. And I think the jury is in now that the most effective forms of learning are action learning. Now, how in our COVID environment and with population growth and the diminishing resources of education in educational institutions, do we engage in action learning? I don't think that the youth of today can wait for these new versions and approaches to learning to be given or to be developed. There is enormous power in authentic, direct voices of Indigenous people, young people, women, and communities. The moment something is mediated through existing institutions, power structures, it loses a lot of that authenticity. And the authenticity is particularly important in terms of human rights and values. You don't have to be science informed about values. It may inform you about the urgency of those values. It may change the way you view that these values may be communicated or may be under threat. But each of us is our own expert on the values and the kind of communities that we want. So I'm talking to you now not as an older person, probably responsible for the world as it is now, in spite of many efforts to change it. I began my life as an environmental activist as a 17-year-old first-year law student. There were very, very few women in the legal profession, and we had virtually no environmental laws, pollution laws, or heritage laws. We could see out-of-control development all around our cities and the rapid degradation, particularly of our forests. Many of our species were declining. We felt, like you, that we had very little chance to turn it around. So we simply decided to take action, as you are now. And it is effective. The learning process is a journey, and it's a journey that can lead to empowerment. And it can also be a joyful journey in terms of what you learn about yourself and your relationship with other people. So I guess my basic message is the curriculums in your schools and in your universities and the way your community politics operate are not going to change from above. In my experience, that has virtually never happened. There is a certain power in these being these direct and collective voices. And the greatest power is simply not going away. Most of the environmental actions that have been effective have been grassroots, they've been direct, and they're people who are tenacious and simply don't go away. I think the Indigenous peoples of the world are a really powerful statement of that. So I really acknowledge and respect the movement that you're engaged in, and I think it will win. Thank you.
Thank you very much. And now we have to be ready for our last presenter, Miss Robin Goldberg.
Hi, everyone. I'm just going to speak for a few minutes. I have a script. Sorry, I don't have a presentation. So my name is Robin Goldberg, and I'm a second-year student at the University of Windsor Faculty of Law. I'm going to start off by giving you a little bit of background about our school, our region, and the project that we're working on, the first steps that I took in planning, the challenges that we faced, and then the options that we're looking at for implementation. So my school is located in Windsor, Essex, Ontario, Canada, and it sits on the traditional territory of the Three Fires Confederacy of First Nations, which includes the Ojibwa, the Odawa, and the Potawatomi. Windsor, Essex is Ontario's agricultural centre, and Windsor is the largest urban locality in the region, with the surrounding area largely agricultural land. There are numerous First Nations, which is Canada's term for Indigenous nations, in the area as well. The other distinguishing characteristic of Windsor is it being a border city, and it's right across from the American city of Detroit. And the Ambassador Bridge linking Windsor to Detroit is the busiest commercial corridor in North America. In fall 2020, I was a student in the Windsor Law Transnational Environmental Law and Policy Clinic, and specifically the Special Climate Litigation and Policy Clinical Project, and I'm now participating as a volunteer. And so the objective of this program was to provide a guided forum for law students to discuss how Canadian individuals, groups, or organizations can seek climate justice by challenging governments and corporations in court for failing to adopt climate laws and policies, while at the same time reflecting on the urgency of the problem according to science. And so students examined the potential limitations of climate lawsuits and what's worked well and not so well in climate litigation in all parts of the world, and all towards identifying ways to innovate in climate litigation in the Canadian context. So what became clear is that Canadian courts and the legal profession can play a much more active role in addressing the climate crisis than they are currently. And climate accountability is still a very real challenge in Canada. And after learning more about the Youth Climate Court Initiative from Dr. Kearns, we decided that this would be a great way for law students to promote youth awareness of climate responsibilities and accountability at the local level. And we began the process of planning a Youth Climate Court, or YCC, in Windsor, Essex. And so generally our goals for this project align with the broader initiative and are to educate youth early about the responsibilities of local decision makers in addressing climate change and avenues to make local authorities accountable, and also to prepare and equip youth to face the climate challenge head on throughout their lifetime. So speaking to my first steps in planning, so personally, I'm not from the Windsor area, and in fact, most students at Windsor Law aren't. So the first really important step was to connect with individuals who could help me understand the local issues and experiences to inform the design of the Windsor Essex YCC. So some examples. I connected with a municipal councillor, a professor who leads another clinical program focused on municipal climate action, also a group of local youth that are passionate about participating in climate initiatives, and one of our school's Indigenous professors who helped me understand a little bit about Indigenous youth in the region. And an important note is that an Indigenous lens on this project is very important to us because in Canada, Indigenous peoples are the ones facing the brunt of environmental injustices, including climate impacts. And so informed by this and other substantive research, we prepared a primer booklet intended to introduce readers to climate change, its challenges, and potential solutions, hoping that this will help inspire youth groups to participate in our program. And so you might be asking, what is our program? And this is a great question because it's still something that we're working out. And so in this process of planning the YCC in Windsor-Essex, we encountered what I would say are 4 main challenges. The first one is, what should we try to achieve through this initiative? There are many potential objectives for a YCC. So do we prioritize education and relationship building between youth and local decision makers? Or should we be focusing on achieving a tangible outcome that can benefit communities, like a policy, a commission report, or even a bylaw? And so we've landed on trying to find a way to realize an outcome, a tangible outcome, while also achieving public education objectives. The second challenge is, what could be an achievable outcome or deliverable for Windsor-Essex youth groups specifically? And so an important aspect of this is that in Canada, climate change responsibility is complex and multifaceted due to split jurisdiction between provincial and federal governments on climate law and policy. And so, of course, even though cities play an important role in climate mitigation and adaptation, accountability has not yet been clearly traced to municipal actors. There has been no climate lawsuit against local governments in Canada, and nor have we found examples of rights-based climate lawsuits against municipal governments around the world. And so these gaps represent a real challenge in understanding what outcomes youth could really work towards. But at the same time, this gap could also offer an opportunity for youth groups to innovate in showing that local governments should be made more accountable for how their lack of climate action impacts citizens' rights. The third challenge is, how do we attract local decision makers to actively participate in the initiative? We think that this initiative should also serve to make local councillors more aware of the rights implications of their climate actions or inactions. So we want to have them fully on board for this. But we've also learned that municipal councillors or public administrators may be concerned that any opinion that they share through the process could be construed as a political position that they could be held to in the court of public opinion at least. And so the question for us here is, how do we design the initiative in a way that provides public officials with the flexibility to engage to whatever degree they're comfortable? If they want to participate without expressing positions or commitments, how can we make that happen? Do we base the exercise off of hypothetical scenarios rather than real ones? What type of outcome would public officials be more ready to adopt? And do we want to have a highly structured program, like a moot court or mock court, with a judge, jury, plaintiff, defendants, and witnesses, or a more fluid structure, like a commission that is driven primarily by the participation of youth? And so fourth, and bringing this all together, is what type of format should we use for this initiative? Do we want to simulate a traditional court? Or do we go in a different direction with something like a truth commission or something else completely different? And so this last challenge is what we're currently working through. And in developing options for implementing a YCC, we know that as a baseline, we want an initiative that will result in an outcome or deliverable that addresses gaps in local climate policy or climate impacts, and is also properly within the jurisdiction of the municipal government. And we also want a process that attracts public official participants. And so some of the options that we're looking at, I'll briefly review, and along with some pros and cons associated with them. So a mock court is one. And it's an excellent educational tool for youth to learn about the justice system, while also leaving the door open for addressing a matter that could in reality be litigated, as was in Australia from Judith Preston. If we could involve a real judge in this, it would also be a great way to engage more Canadian judges on climate issues, because in Canada, there are no specialized environmental courts. And so not all judges are well versed in environmental and climate issues, so this could help fill that gap. However, that participants might be more tightly tied to or familiar with adversarial forms of the justice system, which in itself isn't always an effective means for achieving justice. And this approach could also deter public officials from participating from the adversarial nature alone. So another option we're looking at is a climate truth commission that would lay bare the climate impacts in local Indigenous groups and other vulnerable populations in Windsor-Essex. And it could be an innovative collective learning process for youth, local officials, and judges, while resulting in a report with a series of recommendations for various local actors and actions. This format would mainly rely on the efforts of youth community participants at the first stage, and it could be followed up by meetings to discuss the report, which could help make connections between the community and the decision makers. Nevertheless, in this scenario, it's less certain that a tangible outcome outside of the report itself could be achieved. And still, facilitated meetings resulting from the process could help parties find a mutually agreeable deliverable that works towards following youth's recommendations that they've outlined. And so the last option that we've considered is implementing the initiative in a school setting. So the planners, which are essentially the TELP or Transnational Environmental Law Clinic team, they could work with a specific school to develop an extracurricular program that engages youth in learning how to advocate for climate action in their communities. Both the initiative format and the outcome may be more flexible. So the format, it could be a moot court, a mediation, listening sessions, any of those. And the outcome could be a report, a policy, or even a commitment. Public officials may also be more inclined to participate in an educational setting because it's likely to have much lower political risk associated with it. And this option could also work regionally, since we learned that we'll get the most significant interest from high school aged youth in Windsor-Essex. This option, though, is somewhat more complex and requires a more significant role from planners. And in addition, if the outcome of the initiative is too flexible and not so clear, it may be harder to garner interest from youth wanting to see more concrete results of their advocacy. And so these are the main questions that we're discussing at this moment as we move forward in the project planning, and learning about the challenges that other groups are facing, like we have today, can help us and will help us navigate this process more smoothly and with a clearer vision of what's ahead and where we're headed. And that's it for me. Thank you very much for the time.
Thank you very much to all of our speakers. We will be moving to the Q&A portion. Just a reminder, anyone who has any additional questions is able to send them through the Q&A function at the bottom of the screen. So our first question says, how do we contact Maya Stout and her team? Is it through Tom Kearns from Keith in England?
Yes, the answer to that is yes. I'm trying to protect them a little bit. So that's the way to do it.
And then our next question is, are there youth climate courts in England? Who do we contact in England if there are?
I'll take that. The answer is no, not yet. But soon to be, because whoever is asking this question is going to organize one, we hope. So, yeah, this is one of the goals of this is that it be a no cost, no barrier form of powerful, direct access to a government. And it needs to be local, because if it's federal or state or provincial, it's so far removed that those politicians at that level don't have to listen to anybody. But if they're from your local city or area and you run into them in the grocery store or walk, then they have to listen to you. They know your parents. They know you know, so they have to be nice to you and they have to take you seriously. So one thing I've discovered is that, you know, it can't be 100% no cost, because somebody might have to print something. And another cost is Zoom, because the regular free Zoom version, if it's going to be held online, it just doesn't work. And in fact, I've been talking to the Zoom folks this week. It's the webinar version is the clearest and the cleanest and the least likely to have Zoom bombers and that kind of thing. And so that costs, I find out, $150 a month. And so I'm trying to negotiate with the Zoom people to donate. Come on, these are kids. This is a public service thing. And so we'll see. Maya, do you want to add anything?
Well, like, honestly, with my experience with this so far, when it comes to how easy it is to actually have a real court and to put this together, it's been one of the easiest projects to take on, because as a Fridays for the Future striker and everything, going out and driving to a building that you can have a school strike at, that is money, and and finding a ride and everything, that costs money as well. So this is kind of like an easier way to kind of just create an outlet for the kids that couldn't show up at this climate strikes, or the people that didn't really have like a ride or the money to pay for gas to get there. And it's accessible for even kids that I have a few kids in my group that their parents don't even agree with what they're doing and don't agree that they're fighting for climate justice. However, they, with their parents' permission to work on this project, they have been able to show up to things and work on it on their own time. And it's just like really accessible for pretty much like no matter what your the consequence or the conditions you may be living with. And I think it's a really amazing thing for kids to do, because you can spearhead it and you can have whatever time frame is work convenient, and it's kind of, you can manipulate it to whatever convenience you need it to be. And it's pretty easily done by you just have to put the effort and commit to it is all.
Can I just ask a question to probably Maya and Robin? How do people find out about it? I mean, what I have learned over the years is that often we are speaking to the converted, which is great. We're all agreeing with each other, but what an objective should be is to be persuading people who will become the leaders of the future that we need to take this seriously, and it's not a liberal or conservative issue, it's a global issue. And so if we want to convince everyone to become involved and empowered, how do they find out about it? I mean, often you might engage with the law students at the university or the students at the school that Maya's at, but how do other people find out? What are the sort of ways of telling other people? You know, do you put it in a local paper, on the radio or on the TV, or what are the sort of ideas about that?
I think that Maya has a much more comprehensive answer, but I can just briefly give kind of what we're thinking in our context. Yeah, I think that's a really good point. And unfortunately, I think in the Windsor-Essex area, we're looking to, at least at the first stage, for the first iteration of this process and this project, be engaging with youth that are on board, and even, you know, maybe even public officials that are relatively on board. They're much more accessible, more readily to say yes. And then going from there, then we can reevaluate how to expand our network. But that's kind of where we're starting off.
Yeah, and this is kind of where we are right now. This is the first time I've actually publicly told what we're doing and what was going on here in Newport, and that we're putting Newport on trial. And so we have a media coordinator and she is in charge with writing a press release and talking to local newspapers. But also the biggest thing that we have, one of the biggest tools, is social media and kind of the idea of reposting. And I run a climate change account on Instagram, and we get lots of people reposting and spreading our posts and pictures and things all over social media and on Facebook as well. And through that, we actually get a lot of people to hear about it. Everyone from my school knows what we're doing when it comes to our climate strikes, and then soon when it comes to these climate courts. So, I mean, social media is probably one of the biggest things, and also public newspaper and local newspaper as well.
I'd like to add one thing to that also, that this is a pretty bold thing, that a bunch of kids are going to put their government on trial as if the government is a perpetrator, which of course they are in these cases. So they're going to put this government on trial. They're going to go to the government's weekly or monthly meetings, point their finger at them and say, we are putting you on trial. We're asking you to send a representative. The representative doesn't have to personally believe A, B, or C, but they need to speak for the government. So in response to one of your concerns, Robin, a representative, a political representative, might be able to, whenever they speak publicly around this court thing, might be able to say, I'm not speaking for me, I'm speaking as describing what this government's position is. They might not say, I agree with it, or I disagree with the government's position so far, but here's what they have done. So on the letting people know, I think, you know, once there's a newspaper article about it, or a radio account, or people are going to start saying, what? These kids are doing what? And so I think the boldness of it, as opposed to other models, you know, the boldness of this is pretty serious, and it's going to demand something. So these, you know, the team will show up at county or city meetings, and they will be demanding things of this government. And once mandates have been issued, then they, you know, have rallies saying, how come the government isn't following through on what they were, et cetera, et cetera. So
I think the other important thing is part of the sense of despair is that traditional forms of political power or protest, like the vote, direct action, in themselves have appeared to be less effective. Therefore, we've got to develop new strategies, and things like the role of comedians, the role of humour, the role of art, the role of theatre and drama. And I think the idea of the climate court as effectively theatre means that you can sometimes say things more directly and powerfully, and in a way that people will listen than you can in other forums. So I think that aspect of it is worth reflecting.
So our next question reads, oh, does anyone else have anything to add before we move on to the next question? Our next question reads, were there any lessons learned from the Our Children's Trust case? I think that's the Juliana versus you.
I can respond to that. The main thing, you know, I have such admiration for the Our Children's Trust folks, and for the group of young people, and for the persistence and just dogged determination of never giving up against, you know, virtually impossible odds over the last many years. They were taking to court the most powerful nation in the world. the most powerful corporation in the world was an intervener in that case. And so, and they continue to do it. And that is, by the way, a largely rights-based case, constitutional rights mostly in the US, but those overlap with human rights standards too. So yeah, I think there's a lot that youth claimant courts can learn from other cases like Juliana and La Rosa and Urgenda and many of those rights-based cases that are having a lot more success in the world than statutes-based cases have had. So I'm imagining youth climate courts can learn from those rights-based cases, but I'm also imagining that youth climate courts will be a benefit. We'll be able to help and raise awareness and show from the bottom up. Those are top-down cases, that's an important approach, but these are bottom-up cases supporting those legal cases from below.
I just wanted to mention, of course, some of these cases that we see, you've got to remember that they're very specific to the jurisdiction. So sometimes they're related to rights that you might have in statutes. Sometimes the standing rules. I think in the Juliana case, there was issues in the lower courts about whether or not the plaintiffs had standing, which is the ability to actually get into the court and argue the case. Some courts, if they're a little more progressive, don't worry so much about the standing, even if there aren't standing rights in the legislation to get into the court. They want to look at the substantive issues. They'll sort of give them the discretion to actually approach the court and argue the substantive issues. The other thing, I suppose, is that it shows that capacity building for judges is extremely important. I mean, there are a number of global bodies and academics and practicing lawyers that are working on improving the knowledge of decision makers, including judges. So it demonstrates to me that we've got a little way to go in terms of getting decisions, but I do feel hopeful because I've just been reviewing climate litigation, which is very much one tool. Climate litigation, I always feel that litigation is it's a blunt instrument in terms of change. It's very, very effective, but it's very slow. So you need to look at problem solving of the climate crisis by using a whole range of tools. So litigation is one of those. Youth climate courts is freer in the sense that you don't worry about whether or not people have the ability to come to court. We welcome everybody to come in and tell their story. So we've also got people who are making, if you like, decisions or making restorative justice plans, who are well-versed and educated in the issues, so that they're very creative in what they think that the forum can do. So.
One thing that I also wanted to add on this question. So yes, Our Children's Trust cases, I think, brought at least our group a lot of lessons, and not only Juliana, but also the La Rose case that was unfortunately struck out before it could proceed to trial, which was a suit by youth against the federal government, and Our Children's Trust supported that. There's also an ongoing youth-based suit against the provincial government in Ontario that Our Children's Trust isn't involved with, but it is actually proceeding to trial. And so some of the things that I did to use that information when I was creating this kind of primer booklet to ideally be distributed to people who might be interested is go through the pleadings and see exactly, what these youth are saying the impacts are in their everyday life, and pulling out some of those stories and displaying them in the booklet so that youth reading it can see, okay, like this is kind of what they're talking about in terms of these rights-based claims. Am I feeling anything like this? And the Juliana pleadings were really, really helpful in that way. And if you're interested in the Ontario case as well, it's called Mathur, Mathur v. Ontario. And that is being led by eco-justice.
And I just add one minor, well, not minor, is the urgency. You know, this is not something that needs to be solved over the next 3 or 4 decades. This is something that needs to be solved in the next few years. You know, I was on a panel yesterday, and one of the panelists was a human rights attorney in Alaska who helps native people in native villages, which are literally being destroyed. I mean, physically destroyed. Their lands, their traditional lands are washing away with the sea. Their storage, food storage facilities in the ground are not working anymore because the tundra is melting and filling with water and that sort of thing. So, and she tells us climate forced migration, which we're already seeing, is going to become enormous within this decade. So that's within the next few years. And I think adults don't appreciate the urgency as much as young people do. I think young people get it. And people who are older, who have a fairly, you know, have found their footing, their sea legs in the world, more or less, just, I'm not sure why it is, but don't feel the urgency quite as much as young people do. So this climate courts option gives them immediate, you know, so these students in Newport say, we want to do something quick. They can do something by May. And in May, they will be putting enormous pressure on their little government because it'll probably be held online. And that means how many people will be watching this around the world. And these poor, I just imagine these poor Newport city councilors thinking, oh my gosh, how are we going to handle this? We're going to be on trial. We're going to be there. We're going to be, you know, if we're not careful, it's not going to make us look very good. So I think it's got a bold, creative, young power that many other tools just don't have. So.
All right, our next question is a little bit long, so I'm going to remind our panelists so they can read it in the chat box as well. It's on the same case. The government's argument on this subject typically turns on the redressability issue, such that the court cannot provide adequate remedy for the youth. This was, in fact, the dispositive issue in Juliana versus the United States. And the court has traditionally agreed with the government in that regard and has viewed climate change as an international issue. With that said, my question is, how can the United Nations provide a remedy for the youth in face of the harms suffered by climate change? Or can the UN work with our judiciary in this issue?
Go on, Robin.
Oh, I was just going to add something really quickly and not responding to the actual question, but to the prelude. And I just wanted to refer back to the Mather v. Ontario case. So there was just recently in October a decision from a summary judgment saying that the government's motion to strike was denied. And part of what the government was arguing was this redressability and relief issue. And just in that case, the court actually said that, you know, the issue of relief is not something that, like, to strike it so early based on questions of relief and what relief could actually be issued is not sufficient to strike it at that level. So that government actually failed at that section of the proceedings. I just wanted to note that.
Okay, all I'm going to say, I suppose this is turning into a climate litigation panel, I think, but in terms of what the UN can do, there are a number of tools. And what I would recommend to youth and to Indigenous communities and women and all sorts of people that feel vulnerable and their voice is not heard, the UN special rapporteurs, there are so many of them, and they receive individual complaints, and they often will go to countries or receive references, and they work on issues. One that I do know that in Australia with some Torres Strait Islander communities, so that they'd be referred to as First Nations, they are talking about the physical effects and the cultural, intangible and tangible heritage implications of climate change, because there are a number of islands off the northwest coast of Queensland. They're working, and they made a complaint to the UN Human Rights Committee. So the initial response of the federal government is to try and obfuscate the issue, put them off. They're persisting with that. The only thing I would say is that there are so many references that it takes a long time, so it can't be an urgent response. So there are a number of UN bodies that can receive individual complaints. The other one that I suppose hasn't been mentioned, but the UN Convention on the Rights of the Child is one that hasn't had a lot of traction, but could be a way of highlighting not only the youth of the panel we're talking, but even younger generations. I think also one of the things that I have noticed in climate litigation, and has been one of the issues for a number of cases, is the causation issue. I think that's becoming a little easier. So there's a lot of science that tells us that the actions of governments, individuals and corporations in producing emissions can be easily linked to effects that people, human rights and environmental rights that are being impacted by climate change is not so difficult to prove now. So that is an improvement. I do know that the UN Special Rapporteur on Human Rights and Environment, David Boyd, and John Knox, the previous holder of that position, is working with the Torres Strait Islanders. So there are ways of using UN fora and appointees to assist in addressing these issues.
I see we don't have hardly any time, but I just want to take a minute to thank Robin, especially for thinking through all those alternatives and, trying to imagine the pluses and minuses of each one of them. What are the benefits and the not benefits? I think alternatives like that are, and I'm guessing that there are lots more. I'm interested to know and know absolutely nothing about First Nations systems. I don't want to call them judicial systems, but internal systems for handling conflict and making huge decisions and things. Inuit village, for example, that has to can't live on its lands anymore because the sea is encroaching. How do they go about making a big decision like that? To what body do they go? Who are the elders? Who are the mothers? Who are the, and I'm sure there are different models in different traditions. And I think that would be really worth exploring.
Yeah, I can so I'm not Indigenous myself, but I do have a little bit of an understanding of there is a very wide diversity of decision-making and governance process and traditional processes among Indigenous people across, I think, Canada and of course, North America, South America, Australia, everywhere. And, even just in Southwestern Ontario, like if you're looking at, Haudenosaunee people versus, Ojibwe people or people of the Three Fires Confederacy, they all have, very unique legal orders. And at Windsor Law, we're actually the first law school in Ontario to have a mandatory Indigenous legal orders course in our first year, where we learn about exactly what you're saying, like how, traditional decision-making processes. And I think it's a really good point and something that we should and will definitely explore going forward.
And would there be any way that young people in those communities could do something similar to a youth court in that framework?
I think that initially, when I spoke to one of our Indigenous professors here, I mentioned, she said that there's, a really teen group of Indigenous youth in her First Nation, Walpole Islands, which is not far from here. And they all go to a public school that's Indigenous and non-Indigenous youth. And so there's so many different ways that I think it can be implemented. If it's like exclusive to the Indigenous community, I think it's also a question of she just said, the environment and taking care of the environment is part of who they are and what they do every day and with their communities. It's so ingrained. And so the whole concept isn't foreign to them like it might be to other youth. So I think it would be an interesting way to explore, how they want to engage in it with their own community, if that makes any sense. Or if they want to implement or use their own traditions and bring other people in and see how it works in that way too.
Just in a more traditional way, there is a case in Australia called Gloucester Resources. So if you look up Gloucester Resources, you can find the case. It's Land Environment Court, but the Environmental Defenders Office applied to intervene on behalf of local communities, and that included Aboriginal communities to consider the climate change impacts of an extension. It's an extension of mine, or it was a mine proposal. And there the judge felt that we had got to the point where we have to consider the impact of new proposals for coal mines, and that we'd reached the point where, it was an unacceptable point, and this particular coal mine wasn't going to deliver what it said it would in terms of the environmental impacts through its documentation, and that the benefits outweighed the impacts. So Gloucester is probably not exactly on point, but it's one of the first cases to have a Superior Court make a decision and consider that the causation issue, for example, was no contest. That issue that keeps being raised, so we can't prove anything. The science is definitely in there. And some of the impacts of communities that we're talking about were outlined in that case. So it's a good example. But also in Australia, we have a few cases, actually, somebody's mentioned that the corporations, where the corporations could be on trial. There's a few young people taking cases relating to their superannuation, whether superannuation companies are investing properly or making misleading statements, that they want the court to make a statement on, and also suing the federal government about their common law duty to the youth about things that they're not protecting under our primary environmental laws. So.
Thank you. I want to acknowledge that we are running over time, but I wanted to ask two quick questions before we go. One of them is, where will I be able to obtain the Zoom link for the Newport trial when it is issued?
I think the answer to that is we don't know yet. But the place to find the connection would be at youthclimatecourts.org. There's a contact page there.
And then lastly, how do corporations factor into this discussion? Could they be sued in youth climate courts someday?
Maybe. I mean, kids are in control here. The thing is that governments are the ones that have the clearest human rights obligations. So if you want to, if corporations sign agreements to things, to human rights, responsibilities and so on, but they don't really have a formal obligation to stick to those agreements. So governments, that's their job. It's government's job, is to protect people's rights. So if you want rights protected, and rights are clearly undermined with everything related to the climate crisis, then the people you go after are governments. So
Although in the People's Permanent Tribunal, I think one of the first ones are putting BP on trial for, admittedly it was a pollution event, but you can imagine that. And I think in Philippines, if I'm not mistaken, the carbon majors have been, if you like, on trial. They're not in a court, but it's a human rights commission that they're conducting, so that commission will give a result and give the evidence, and that's another way of introducing it. I think also corporations are increasingly having statutory obligations that people can, as we're seeing in Australia, and also they're making statements about what they're doing or what they're subscribing to. So some youth and some not so youth at heart, are taking action under consumer laws to say to them, hey, you're making profits from saying you're doing certain things. Maybe we have a number of companies in the early 2000s that were sued under trade practices law for making false and deceptive statements about what they were doing, what their benefits were. And of course, you know, all the things that they do persuade people to buy their products, and in turn results in profits. So, you know, that's one way of doing it. Violations of human rights are things that are litigated all around the world for violations by corporations. So I definitely think it's a subject that the youth climate courts can venture into.
And I think also human rights are progressively developed. It's not a question of them being recognised by governments, discovered and implemented. And that's where I think the Indigenous Forum, the Self-Governing Indigenous Forum, is a really a good demonstration of the ability to progressively develop and create rights, because I think that's what we urgently have to do.
And one additional comment, what early, I think in my process, thinking through, you know, what is possible, you know, I did think that in terms of, you know, public education, or seeing the initiative as public education and partnership focused, there could be, you know, this could be a platform for, you know, a corporation, let's say a local paper mill or a farm that, you know, wants to be getting more sustainable and wants to maybe like improve their image in the public realm, like to participate in something like this with youth, where in any type of structure or design that is relevant. But I thought that, you know, it could be an option down the road, but you'd have to find but from our perspective, if it's not a real suit, you'd have to find someone that's a corporation that's willing on that tract. But we kind of like parked that for someday, like you said in your question.
Yeah, down the road after there's more experience, more experience.
Yeah, I think it's pretty flexible. The climate court, kind of the way it's formatted in every way, it's like kind of formatted in a way that you could just kind of change it, and it could be for a corporation, but it's totally like up to who's doing it and if you have a corporation that's available for that. So, I mean, if the kids want to put on a corporation and they have someone in mind, I'm sure they could definitely do that.
Thank you all for your wonderful and insightful answers. We are over time, so I think that it is time to wrap up. But thank you for your time, and thank you to all of our viewers for taking the time out of their day to listen to us. Yeah.
Thank you, Lisa.
Thank you.
Thank you, Lisa.
Much.